Hey guys, do you know that Indian Penal Code actually forbids the content which is obscene in nature, the sale and publication? Well, how will you know that a particular matter is obscene in nature? The answer comes from the case Queen versus Hicklin of year 1868. The case was articulated to determine and the court actually gave a proper definition of what content is obscene. What the test actually examines is whether the matter impunged will deprave and corrupt the minds which are open to such influences or not, or whether the hands in which such publication is coming is going to corrupt the minds or not. This test was first used in Indian courts in the case of Ranjit D. Udeshi versus State of Maharashtra. The question in this case were two. Let me begin first with the facts of the case. Ranjit was one of the partners of a firm which owned a bookstall. The book which was sold there was Lady Chatterley's Lover. Two questions were raised while delivering of this decision. First, that the section 292 of Indian Penal Code that actually punishes the sale of such obscene books is violative of Indian Constitution's right to speech of freedom and expression. And second, that the book was actually not obscene. Justice Hidayatullah, while delivering the decision of this case, held that Article 19, Subclause 1, gives the freedom of speech and expression, but it comes with reasonable restrictions that are mentioned in Article 19, Subclause 2 of the Constitution. Thus, Section 292 was held to be constitutional, and the second question, whether the book was obscene or not, was decided by the help of Hicklin's test. The court said that where there is a combination of art and obscenity, the art must be so preponderant as to overshadow the obscenity. And also, the obscene part must be taken as a whole. It itself should be considered, and while considering the obscene part, it must be examined that whether it corrupts the mind which are open to such influences or not, which exactly is what Hicklin's test about. The court decided that the book Lady Chatterley's Lover was actually obscene and the appeal against conviction was dismissed. In India, where a work substantially transgresses public morality and decency, one's right of freedom to speech and expression must give away. Obscenity without preponderating of social purpose of profit is not protected. This was about the Hicklin's test. Thank you so much.